we will be starting the panel discussion, working session number 1. The theme is how the platformers are combating the counterfeit products. And let me introduce to the panelists who are going to participate online. From Cambodia, Ms. Keo Hockley, Deputy Chief of the Mr. Keo Hockley, Deputy Chief of Secretariat of the Cambodia Counterfeit Committee. From Indonesia, Mr. King Wam Chow, the President and Registered Foreign Lawyer at the Loot and Root Network for, and from Laos, Tipachan Chipabon, Acting Director of IP Dispute Resolution, and from Malaysia, Ms. Kara Devi Kairasan, Head of Intelligent Property Unit, Ministry of Domestic Trade and Cost of Living, and from the Philippines, Ms. Christine V. Banglinan Kanlapan, Assistant Director of the Intellectual Property Office of the Philippines, and from Vietnam, Miss Yen Bu, Principal Vietnam Country Manager, and let me give you the name of the panelists here in this place. From Thailand, Ms. Nabarato Tang Kamalasu, Director of International Affairs Office of the Department of Intellectual Property. And from Singapore, Ms. Serena Dressel Chin, Head of Legal Counsel Group. Also from Singapore, Mr. Vignesh Baran from the partner of lawyer and partner of Ariana Goodwill. And two moderators for today, Mr. Yoshifumi Onodera and from Nakamura Law Office, Ms. Yuriko Sagara. These are the two coordinators for today's discussion. So with these people, we'd like to start the panel discussion. And now, for each session, at the end of each session, we will have a Q&A session to invite your questions from the audience. In the audience, if you have a question, please raise your hand. And if you're participating in online, please click the Q&A button on the Zoom system. Depending on the time, it may not be that we are answering all the questions that you have, so please recognize that. And now, from now on, I would give microphone to two moderators, Mr. Onodera and Ms. Sagara. It's your turn. Good afternoon to everyone. Thank you very much for your coming to this Judicial Symposium on Intellectual Property 2023 or JSHIP 2023 in short. Thank you for your participation. Thank you for the introduction. I am Yoshifumi Onodera, attorney at law. Together with Ms. Yuriko Sagara, attorney at law, I will be moderating the working session number 1 and number 2. So for today's working session, in addition to 3 keynote speakers from Singapore and Thailand, from Cambodia, Indonesia, Laos, Malaysia, Philippines, Vietnam, from these 6 nations, we have 6 panelists participating online. These experts represent industry as a platformer, and also the governments who are combating the counterfeits in every nation, and also the lawyers in charge of the IP rights issue. So with these experts, we'd like to have a very good discussion with you. So thank you for your participation to the very last minutes of today in advance. Now, first of all, the topics for today. So today's topic is how to combat the counterfeit products on the issue platformer and also the collaboration between the private and public sector and also international collaboration. In the working session number 1, we will talk about the platform-related issues for the counterfeit products. And number 2, public and private sector collaboration and international collaboration will be talked about. So we are seeing the expansion of the e-commerce very rapidly, and the rights infringement over the platform is becoming a very major problem. So far, cross-border control and the control by the police and also the civil and the criminal actions, these were the tools that we used to use in the past, but these are not enough as of now because all the e-commerce transactions are many. So monitoring many transactions on e-commerce is very difficult. And also, as you listen to at the time of the keynote speeches, the platformers such as EC sites will go across the borders. And also, they have the capability to manage their own platforms, and also they can stop or eliminate the accounts if those accounts are infringing the rights. So, with a simple, easy principle or the regulations, it is now becoming possible to control the infringing products. So, the EC site or the platformer is playing a very important role in combating the counterfeit products. So, looking at the past cases and border controls, compared to these traditional weapons, very simply, very shortly, the takedown can be achieved if you pay attention to the platforms. However, on the other hand, there are some technical problems because the private sector has some limitations in its authority, and also there is a conflicts or the conflicts difference among the different players, such as the platformers, and also what is the best practice for the consumers will entail a very complicated discussions. And also for the counterfeits over the e-commerce, if the private sector and public sector will be doing independently, it will be inefficient. So combining these two, I think we can have more power to control the counterfeits over the internet. And also for the e-commerce problem, across the border collaboration or the international collaboration is strongly required as of today. Therefore, in the working session number 1, we will talk about the countermeasures for the counterfeits by the platformers. And in the networking session number 2, private and public collaboration and international collaboration as an anti-counterfeit is going to be discussed. And now, for the working session number 1, we will ask this question: what are the legal restrictions that platform providers of e-commerce sites have to abide by? And also, question number 2, what measures against the counterfeit products are being taken as self-regulation? And for that matter, we have listened to the case of the Caruso already in details. And in working session number 2, question number 3 is to crack down on the counterfeit products effectively. What are the measures that we have to have through public and private partnership? And the question number 4 is about the international collaboration. So let's start working session number 1. I will be taking care of the working session number 1. So, question number 1. What are the legal restrictions that platform providers of e-commerce sites have to abide by in relation to the measures against counterfeit products? So this is the question number 1. Now, from myself, I would like to explain about the Japanese systems. I will give you a brief introduction to Japanese system, which may be known to the Japanese audience already. But as an introduction to panel discussion, please bear with me when I speak about the Japanese cases. So here in Japan, in addition to Intellectual Property Rights Act, there are no special regulations or acts which will force the platformers to do something against the counterfeit. However, the platformers have to manage their own platforms. So if they notice that there is an infringement over their platform, and then the platformer has to take a step, because the platformers sometimes are regarded as an infringer if the infringing products are going to be distributed on their platform. So they might be sued by the right owners. The platformers are just providing a space or the e-shop over their platform. That's one of the typical action by the platform. Those platforms do not sell or buy anything. They are just letting the e-shops use their space. And in that case, if there is an infringement on their platform, meaning that the e-shops are just selling the infringing products, then it is too much for platformers to be held responsible, because it is difficult for them to grasp all the transactions over the platform. Now, here in Japan, we have the Provider Liability Limitation Act, Article number 3, which will limit the liability in damages of the providers for any transactions done on their EC sites. Complying with some conditions, providers are going to enjoy the legal exemption. And also, to comply with these conditions, they are highly motivated to interrupt the illegal transactions over the internet. So this is a motivation for the providers. This is sometimes called safe harbor regulation, and the following discussions will bring the attention to the safe harbor regulations from several countries. Now, provider responsibility is restricted according to Japanese law, and there are two such cases. Number one, for the trademark rights holders, when they are sued, they can be exempted from the liability in damages for the authentic right holder. For instance, the right holder will inform the platformer that their right is infringed over the platformer, and then platformer comes to know that there is an infringement over their platform, and then they will be exempted from the liability if they delete that content in a reasonable time. If they don't take down, and then they may be sued as a responsible person. So this is the incentive for the platformers to take down any infringement over their internet. And next case, the shop owners whose product was reduced or eliminated from that platform, they may come to the platform asking this question: why did you do that? Why did you take down our product? So this is the Article number 3, Section 2 of the Provider Liability Limitation Act. So those platformers taking down the products from the e-shop over their internet, they may be sued by the e-shop owner, but in that case, if they satisfy several conditions, which is listed here, they will be enjoying the legal exemption. And now finally, let me talk about the center of the information disclosure according to this act. Infringing act over the internet, and because the internet is an anonymous world, it is difficult for the providers to know that infringement. So it is obliging providers to disclose the information of the sender with some conditions satisfied. And this has enacted, and this has revised as a new act in 2022 as a part of the Japanese legal system. So very quickly, I have explained to you the Japanese legal system concerning the counterfeit. So let's start the panel discussion.
So in this slide, I have a list of the topics of the discussion. And I summarized answers from each panelist. So I would like to use these materials for the discussion. Regarding question 1, I would like to introduce the panelist, and I would like to ask reply from each panelist.
Thank you for waiting. So, shall we start panel discussion? First of all, I'd like to ask one question to Mr. Keo from Cambodia. Mr. Keo, can you hear me?
Yes, sir, I can hear you.
Okay, so I heard that selling a goods not on a typical EC site, but Facebook or other SEN, not typical EC platformer, are very common in Cambodia. That is not a typical EC site. Specifically, a lot of sellers are offering various goods on Facebook, and end consumer send a message on Facebook to seller to order the goods. So in such unique circumstances in Cambodia, so your office, you have the authority, regulating and combating counterfeit goods. So does your office have any experience to find the counterfeit goods on Facebook in your country and punish sellers? Could you please introduce?
Yes, sir. Good afternoon, everyone. Thank you very much for the questions. Yeah, it's true that in Cambodia, we for products online, but most of the time now people prefer to use Facebook page, and they do live streaming to broadcast their products online. And this, when we found out that it's a counterfeit product due to tip-offs from their competitors or from consumers, or maybe sometimes from the competent authorities. So we need to track them and trace whether the products is stored in which warehouse or in which address. But it is very difficult because the transaction is like this. When they sell their product online, they hide their warehouses, and they would go to the delivery man, the office, and then send the product to us. So when we got the product, or the consumer, the end user got the product, they need to pay on that spot, or sometimes they use a local ABA or local bank apps to send the money. And then we need to follow the delivery man in order to find the address. But it's still difficult to find them. But sometimes it is successful when we use our right resources and people to follow the source, and then we can catch them and apprehend the infringers and send them to court for prosecution. Yeah, there are several cases that were successful, and I would raise one high-profile case, but not successful. There is a complaint from a big company from Thailand. They complain about a company that show online on website and on Facebook page about agricultural products that are imitate their original product from Thailand, and then file a complaint and send us all the pictures, the web page and the website, and then we analyze that and we send our people to look up those information to investigate. But later on, we cannot see, they take down all the web page and the website. So it's like that, and they change the address. So it means that we don't have enough proofs to prosecute them. So far, we still cannot do that. So it is an unsuccessful case, one of among the other cases. Yeah, I can tell you briefly like this. Thank you.
Thank you very much. Thank you, shared great experience. Very informative. Okay, let's move on to the Indonesia. Hi, Kinwo-san. Can you hear me?
Yes, I can hear you.
Thank you very much for your participation. Yeah, this is a summary of your answer for question 1. Yeah, and so I have a couple of questions to you. And based on the regulation number 80 on the slide, what kind of remedy IPR owners can enjoy against the counterfeits on EC format?
So the brand owners, they are entitled to ask for the removal of the infringing listing. And this request will have to be complied by the platform owners in order to avoid liability. And this sort of requests are usually complied to by the platforms. Some take longer than other platforms. So sometimes we need to follow up with the platforms before they comply with the request. The consequence of non-complying is that there may be administrative sanction from the government. But we have not come to that stage yet where administrative sanction has been given against any platform. So we are still at the stage where sometimes it takes longer, sometimes it takes faster, and there's no real consistent approach from the platform owners. Thank you.
Thank you very much. So let's move on to the next, very interesting. Thank you. Let's move on to the next question. And you also explain, introduce, it's circular number 5. So please explain how this, safe harbor based on this circular letter number 5 works.
So in the circular, I think it's meant as a guidance because it's just a circular letter. It's not from the parliament or from any ministry. I mean, it's from ministry, but it's passed as a circular letter. It's not passed as a regulation. So in the circular letter, for the low priority sort of hosting, that's not terrorism. So that includes IP. When there's a request for a takedown, the platform has to do so within 7 days. And if this is not done, again, the ministry may impose sanction. And one of the possible sanctions could be blocking of the website. But that has not happened yet so far because, like I said just now, they do respect requests for takedown. And that happens, but sometimes it takes longer, which requires follow-up. So that's what's happening in Indonesia now. Inconsistent in the approach, but the takedown request will finally happen. The question is how long it takes. Thank you.
Interesting. So what is unclear and issue here in your country?
So
go ahead.
The funny thing is that the regulation say that the platforms are exempted from liability, but the question is what sort of liability? Because the laws of the IP laws only define the traditional infringement. So in terms of traditional infringement, if you've got trademark, you're talking about use of the mark on the goods. So this is how we define infringement, use of mark on the goods. And the normal understanding of use of the mark on the goods is selling or applying the mark on the goods itself, that means as a manufacturer. So the question then is, if the goods are placed on your platform and you help to advertise the goods for sale, is that infringement or not? So that's still not clear. So in some cases, we do advise clients to register their trademark under Class 35. because Class 35 includes online sale of online use of your mark in a retail platform. So there is some measures taken by some IP owners to try to make their position stronger against online infringement. But still, I mean, the position is still not clear. What is the liability of an e-commerce platform? Thank you.
Thank you very much. So, Big-Nish-san, do you have any comment on Kim-Wo-san's explanations?
Well, I think I found it very interesting to read about this circular letter, though the legal effect is in doubt. And I think this is quite opposite from the situation we have in Singapore, where there's no one authority that's even issued such a circular letter to begin with. So, as I said before, there are no specific rules or regulations outside of the traditional law that e-commerce platforms have to abide by. But the point that Mr. Chow mentioned about safe harbor provisions is one of the things I touched on in my presentation earlier, that I think safe harbor provisions are a good way to incentivize the platforms to adopt a code of practice. Before the regulator or the government gives you the ability to run into the safe harbor, you take some steps first as the platform to show that you've done what you can to deal with the counterfeit products. And the safe harbor that I'm talking about is one where you are safe from an infringement action from the IP right owners, not the regulator that's going to take action against you, but to prevent you it's going to give you immunity from an action in infringement. The last one I want to comment on the answer from my colleague from Indonesia is that their definition of use in trademark was particularly interesting for me to hear, because their definition of use is used on the goods. Now in Singapore, when it comes to trademarks, we define use of a trademark as use in the course of trade. And in the course of trade can include advertising. Now this question has not arisen in Singapore yet, but an argument can be made that the platform is actually using the counterfeit goods. When the counterfeit good is listed on the platform, the trademark is actually been used by the platform as well in the course of advertisement, because that's what the marketplace is meant to do. It's a place to advertise, but the sale contract is between the seller and the eventual buyer of the counterfeit product. And this is a very interesting way of looking at this issue. The definitions are not really the same, and how the rights that an IP right owner may have in Indonesia and Singapore may be very different. Thank you.
Thank you so much. So we have a 6 panelists. So let's move on to the other country, the Lao PDR. Tipa-chan-san, please explain more detail about the platformers' obligations to remove counterfeits based on the IP law in your country.
Good afternoon. I'm from Laos. About the experience about the platform in Laos. In Laos, about when have the infringement or counterfeit product in Laos, we will use the IP law to protection by the right owner, and we don't have like a economic platform law or regulations. But in this part, we will use like a IP law to protection about the trademark and copyright. And when we have the infringement of counterfeit product in Laos, like I told you before, in Laos we will like consider by the right owner to sending the document or evidence to us, and after that, our IP will consider by the Article 124 and Article 125 and Article 276. Sorry, because in the IP law in Article 174 will cover about the unfair competitions, and Article 125 will cover about the trademark counterfeiting. And this part will have like we say in the law, we say unauthorized use of the trademark is considered violations of the trademark owner right, like creating, selling, offering of the sale and advertising, marketing and exporting or importing counterfeit trademark goods is a violation of this law. And another article is 126 is about the copyright infringement and who is use the word if don't have the permission from the right owner or use the production, selling, offering, advertising, marketing, and exporting or importing the copyright good. It is considered a violations of this law. That's meaning like if the person who use the trademark or the copyright, if they have the permission or they have the authorized by the right owner, will be like infringement. And we will consider by the two articles in Article 125 and Article 126 to consider about the counterfeit product or who is infringement. And after that, this like e-commerce platform will have like the big price, and we will consider by the law of the customer protections, and this law of customer protection will like protect the benefits or the quality for safety for the customer who is buying buy the product from the platform. And we will use the law on mediation to like consider the content in the platform, and use the on the telecommunications, and law on the privacy of conducting cybercrime, and law on electronic transactions. And the last one, now we use the decree on electronic commerce by the government to handle all about the counterfeit product in the e-commerce platform.
Thank you very much. A lot of laws relevant.
Yeah.
So what kind of policy and procedure does the decrease on electronic commerce require?
Like I told you before, in like all the procedure in Laos, we the conduct voluntarily by the right owner and use the administrative procedure to solving this problem. And about the policy regarding on the law electronic transaction required and electronic e-commerce, we have the notifications, acknowledgement, and permission to conduct e-commerce business. Like if the business they want to do the e-commerce platform, they should be come to register in the internal trade department for telling our ministry they will do the business in e-commerce. And if they like they don't follow the rules from the Article 22, like provide information about the product or service that is inconsistent with actual product or service, or unauthorized use or describing of the custom information, and that's provisions for the electronic it would be like if they don't following the loop in Article 42, and like they how to say their lie or their certificate will be cancellation or will be revoked. Yeah. I'm not sure it's clear.
Yeah, thank you very much. It's very informative. So it's a very many of laws relevant. Yeah, in Laos. Thank you so much. So let's move on to the Malaysia. Miss Kara-san.
Yes, Mr. Onedra.
Okay, so in Malaysia, there are also very interesting system, I think. So here, you introduced the MC notification. So what is the MC notification and how this notification works?
Okay, in Malaysia, the IP laws are basically parked under the Ministry of Domestic Trade and Cost of Living. That is where I come from. However, when we do all these notice takedown or content removal or site blocking, the powers are actually parked under the Communication and Multimedia Act, which is under the MCMC, or we call it a short form MCMC, which is Malaysian Communication and Multimedia Commission. So the ministry works together with MCMC. So we get all this taking down, content removal and site blocking through the notice issued by MCMC actually.
Let me ask you one question. MCMC is a general authority to make a punishment, but your authority is focusing on the IP. So both office co-work together, and then MCMC finally makes a notification. Is that right?
Yes, for IP matters, yes. For other infringement directly, the ministry takes care, but this is on the platform, online. So when we do take down, MCMC has the power usually. So we use their power, so we work together.
Okay, you are the IP authority. Okay, so as introduced in keynote, so a lot of platforms has a voluntary notice and takedown system, not based on the law, but the platformers voluntarily combat the platforms, counterfeits. So, but you have also the MCMC notification. So what kind of case is fit for this procedure, MCMC notification? So what do you think relationship with a platformer's takedown and this legal platform?
Okay, usually what happens is if you are a trademark owner or a copyright owner, you come and make a complaint when there's your goods or your services or whatever has been infringed, or it's in the advertisement or in a website. They'll come to the Ministry of Domestic Trade and lodge a complaint, and they produce all the relevant documentation to us. And with this, we will get the cooperation with MCMC. We'll write to MCMC to either remove the content from the platform, if it's, let's say, any electronic commerce platform which is selling any goods, we'll try to remove the content. But if it's a website which is streaming any of the infringing copyright items, then we'll do site blocking through the provision of the law itself.
Thank you.
So as sorry, I think I didn't answer on the relationship so far. When we have given the notice, the platforms do comply and they remove the content, and we have no issues. As for site blocking, we usually send off the notice to the ISPs, and if they are delayed, we usually send them a reminder, and they will eventually take it off as well.
Mm-hmm. Thank you. So let me ask Serena-san from Carousel. So do you have any comment on Malaysian answers from the perspective of a platformer?
Thank you, Onedra-san. So I My perspective is that it is very interesting and welcome. It's a welcome perspective in that sense where the authorities take a more active role in actually combating counterfeits in that sense. So as shared earlier, the takedown processes can be a bit manual. Typically, the platform owners will also have to check whether or not the person sending the request has the authority to take it down, whether or not they even have protection in the relevant markets. So when it comes from an authority in that sense, it gives us more comfort also. So maybe we only need to check whether the email or the request from the authority is actually legitimate. But otherwise, this is actually very welcomed in that sense, where there's also a trusted platform that we can go to and also to understand more in relation to these takedowns as well.
Thank you very much. Okay, let's move on to the Philippines. Christine-san, can you hear me?
Yes, good afternoon.
Good afternoon. So this is a summary of your answers. And what are the requirements for platformers shall be held reliable in the same manner as counterfeit sellers? You know, in your country, the platformer is possibly liable for infringement, as same as a shop operator.
Yes, in order for a platform to be held liable in a manner similar to that of the counterfeit sellers, in the Philippines, there are a number of standards and conditions that must be satisfied. And the liability for online platforms is governed by the, as seen in the screen, the Electronic Commerce Act, the Consumer Act of the Philippines, as well as the Joint Administrative Order issued by and jointly enforced by the Department of Trade and Industry, the Department of Agriculture, Department of Environment and National Resources, the Department of Health, also the Food and Drugs Administration, the Intellectual Property of the Philippines, and the National Privacy Commission within their respective jurisdictions. And the liability would depend on whether the platforms have complied with the following key elements. So the platform must have policies and procedures in place in order to monitor and remove infringing or counterfeit products and sellers in their sites. So this includes regularly checking for and responding to complaints regarding counterfeit items. Second is that the platform should implement an effective notice and takedown system. So when they receive a valid complaint about counterfeit products or IP infringement, they should promptly remove or disable access to the infringing content. Third is that the platform should have terms of services or user agreements that clearly prohibit the sale of counterfeit products, and the sellers must agree to these terms when they register on the platform. Next would be the platform should provide a mechanism for users and intellectual property rights owners to report counterfeit listings or infringement. And the platform should also require the sellers to provide accurate and verifiable information, including contact details, and should verify the identity of the sellers to the extent possible. And the platform should also cooperate with law enforcement and IP rights owners to identify and take actions against counterfeit sellers. And lastly, the platform should retain records of the sellers as well as the transactions, which can be used for investigation and enforcement for violations of intellectual property rights, such as infringement. Thus, in conclusion, if the platform owners do not comply with the above elements, then they can be held liable for infringement as well.
Wow, so many requirements. Yeah, you know, that does platformer fulfill, comply with all the requirements you mentioned to you know, not too reliable for the infringement?
Yes, they do, because of course they want to do business in the Philippines and therefore they would have to comply with the local laws.
So, excellent, thank you very much. And so, as you mentioned, in Malaysia, so the platformer is obliged to disclose exact information, exact in the identification information of the potential infringer. So I'm so impressed. So let's move on to the next country. We have two more countries, Thai and Vietnam, but Nabarat-san is already explained details in keynotes. So I will skip the Thailand and then firstly go to the Vietnam. So Yen-san.
Yes.
Thank you very
Hi.
much for
Hi,
your
everyone.
participation. Here is your answers. Yeah, please explain how does a safe harbor, so we already discussed about several countries. So in Vietnam, how does a safe harbor works for platformers?
Thank you, Honorable San. So for Vietnam, like some countries in the ASEAN region, Vietnam laws do not require e-commerce platform to proactively tackle counterfeit on their stores. So e-commerce platform will enjoy safe harbor so long as they have a sufficient notice and takedown procedure in place and comply with regulations on tackling IP infringement. So to be more specific, there are four specific obligations that they need to comply with to enjoy the safe harbor. Firstly, they must remove infringing content within 24 hours upon receipt of the competent authority's request. Now, some people say, well, this is a very tight deadline, only 24 hours for e-commerce to
24
comply.
hours. Yeah.
And actually, we understand that some e-commerce platforms are very keen to comply with this requirement to enjoy the safe harbor. So whenever they receive a request coming from competent authority, they would remove it, the listing reported right away. So the second obligation is to cooperate with IPR holders in monitoring and removing infringing listings in compliance with the e-commerce platform's regulations on operation. So this is the notice and takedown obligation. And from our observation, almost all e-commerce platforms, especially the major one in Vietnam, they all have a very effective notice and takedown procedure in place. The third obligation is to give a warning to or refuse to provide e-commerce platform services for a fixed or indefinite term to sellers that violate the laws. So to comply with this obligation, we've seen that e-commerce platforms usually include a provision in their policy to all sellers listed on their platform.
Removing infringing goods, within 24 hours, based on the authorities' request, is amazing. So, is such kind of a procedure is very common in Vietnam? There are a lot of cases.
Yeah. So thanks for the question. We don't have any official statistics here, but we do understand that the authorities do sometimes request e-commerce platform to remove infringing content. For example, some copyrighted violation content or counterfeit that they spot or they receive reports about these infringing listings on a certain e-commerce platform. So that do happen.
Thank you very much.
Yep. And finally, the fourth obligation of e-commerce platform is to assist competent authorities, investigations and handling of IP infringement acts. In particular, they must provide competent authorities with information about sellers on the e-commerce platform with IP infringing signs or acts upon detecting or receiving such information. And they also need to frequently update keywords as recommended by competent authorities and filter information on goods and services using keywords before publishing it on the website. And finally, they must receive and respond to IP infringement complaints on the e-portal of the Ministry of Industry and Trade. So this portal is a government portal. where consumers or IP owners can use to report infringing listings. So from time to time, if related to any e-commerce platform, then they need to review and remove the infringing listing reported in this portal.
Looks like too much burden for platformers.
Yes, indeed.
Yeah,
But so far, we've seen that the e-commerce platforms, you know, they all have their internal policy on detecting and handling IP infringement cases, as well as having a quite effective notice and takedown procedure.
Okay. Thank you very much. So let's move on to the question 2. Yeah, question 2 is, what measures against counterfeit products are being taken as a self-regulation by major e-commerce platform providers in addition to the legal restriction? As Serena-san detailedly explained the case of Carousel, the major platformers providing so-called notice and takedown systems. Here is an example in Japan. So a lot of major platformers in Japan providing a similar system. And also that the guideline for the Provider Liability Limitation Act guideline and as a I'm sorry, yeah. The guideline is set also by the private sector. So let's begin the discussion over the question 2. The major platformers in Asian region and major platformers notice and takedown system and current legal issues and advice to IPR owners from each panelist. So that there are many major platformers in Asian region as well. Take a look on the slide. Carousel, Shopee, Lazada, TikTok, eBay, Muda, Tokopedia, and Bukalapak, etc. So that these platformers prepare and provide a notice and takedown system in addition to the legal system. And so first of all, I would like to ask the Serena-san. Yeah, I'm so curious, so impressive keynote speech from her. So my first question is, does Carousel provide a common standard notice and takedown system in multiple all the jurisdiction you are doing business, or localized in each jurisdiction?
Thank you for the question, Yoshi-san. And also thank you for actually granting us the title of a major platform in the ASEAN region. We are working towards it. So to answer your question, I think it depends on a few things. So as shared earlier, Carousel we have a family of brands and we are also in many different markets. So we try to apply similar principles across, because from a business perspective as well, it has to be scalable in that sense. So we have a baseline principle or must have. So each market, for example, each business entity will need a takedown notice process, and we follow certain similar principles, but it's also very dependent on the platform itself and also the market that we are in. As shared by some of the other panelists earlier, you can see that the takedown requirements for each market differs and can differ quite quickly. So to the extent that we can, and it's also reasonable for the business. So for example, we know right now there's a 24-hour timeline, for example, for Vietnam. We hold ourselves to that standard across all the different markets. It is harder from a business perspective, but that's what we try in that sense. And it's also, so yes and no to your question whether we can have one. For example, in Malaysia, we have two different brands. We have Muda and we also have Carousel, where the tech stack that the platform is being used on is also different. So the traditional takedown process could be the same or similar, but what we build on for more effective takedowns like crop may not be able to be as effectively applied across all as well. And for some of the other markets, we also see that there are requirements to be afforded the safe harbor protection, where we might need to give a notice in a specific manner, and that gets a bit tricky, and we will have to adapt accordingly.
Thank you very much. So what is the biggest challenge in past to comply with any local restrictions?
So I think from a business perspective, the biggest challenge would be, of course, if I had it my way, I would make sure that we are compliant to the T for every single market. But it comes in, the difficulty comes in the cost of compliance, in having to apply the strictest protection or strictest guideline across all the different markets, where some markets may not require us to have that level of process, or how stringent that process is. So these are some of the challenges that we have, where it's balancing the interests of the different stakeholders. So it could be rights owners, the authorities, and the business and the users ourselves. So for example, in Safe Vietnam, as shared earlier, there are certain safe harbors for us as a platform, or in some of the other markets, and in Japan as well, as you shared earlier, where platform owners can also be exempted from liability, not only from rights owners, but also potentially in the actions that we take for takedowns, and it might not be the same across. So while we might want to be more proactive, in some markets it may not work. So the difficulty comes in also training our employees to be able to identify when it can be applied, and which takedown notice can certain processes be applied.
Thank you very much. So you mentioned a lot about Vietnam, for example, Vietnam safe harbor. So Yen-san, do you have any comment on Serena-san's concerns and experience?
Yeah, so thanks very much, Serena-san, for your comments. I mean, you know, even though the liability, the possible liabilities for e-commerce platforms if they don't comply with safe harbor is not very severe. Upon our checking, there is a fine against you know, e-commerce platforms, and it's not very big fine, but we do see that, you know, all of the e-commerce platform operating in Vietnam are doing their best to comply with the regulations, and especially to comply with the very tight deadline whenever they receive requests coming from the competent authority. So that's very encouraging to see.
Thank you very much. My next question to Serena-san is, you know, yeah, it's my interest, you know, that an IP owner which has a special request, it's a very strong brand or a big company, or not so much, but in any case, so if the, you know, specific company requests to do special treatment, special measures on counterfeit or illegal contents on your platform. So do you have any experience on the work with specific brand owners in a special project or something like that?
So thank you for the question. As I shared earlier, Carousel is a multi-category platform. So we do our best to collaborate with different brand owners, but sometimes it gets difficult to apply a particular rule across the platform, because it may work in one category, but it may not work in another category. But we do have examples of actually working with rights owners as well to find, particularly also because, as alluded to by Mr. Vignesh earlier also, there is a alignment of interests between platform owners and rights owners, largely also being users' interests and consumer protection. So if we use the example of pharmaceutical drugs, there is a higher risk of having counterfeit drugs on our platform. We will also be more intentional in actually collaborating with the pharmaceutical companies as well to be able to better identify it. And we will test it on our platform to see whether it works and whether some of these rules that we put in place will be effective. One example also, if we look at, say, the fashion or the luxury space, we have tried implementing certain measures like price indicators to remove counterfeits on our platform. But it gets a bit tricky also because within the fashion category itself, different brands have different prices for their bags, particularly for secondhand. It really depends on the seller. It could be a Chanel bag that $4,000 may be okay, or it could be another brand where it's a high street fashion brand and someone might only decide to sell it for $150. So applying some of these might be a bit difficult, but we do try to collaborate with the different rights owners. So you can send me an email or to the email. We have a help center on Carousel. We are always happy to have more conversations to see how we can have a more effective way of targeting certain counterfeits.
You are so kind. So do you recommend contact you when Japanese or international brands has some issue on carousel?
Definitely. I think it's faster also sometimes as opposed to going through some of the more traditional channels. So please feel free to reach out.
Okay, good. Thank you so much. The other question is, I'm so impressed your presentation. It's you are utilizing great new technologies, AI, data science, image search, and etc. And so that you are investing a lot on a new technology. So do you have any legal issue utilizing these new technologies?
So I don't profess to be a IT or tech expert here, so any of the panelists, please feel free to jump in also. But from our perspective, there are three main buckets generally when it's using machine learning or AI. Largely, one would be the legal piece, like you mentioned, commercial concerns, and also potentially ethical and moral concerns as well. Specifically for legal, I think it's a little bit more traditional as to whether or not we are using confidential information. Are we disclosing personal data? What could actually be used? How would that data actually be used when we send it to another third party or a different system to be able to build up these AI or machine learning capabilities? And how even more technical would be, how is the information sent? Is it in a secure manner, or is it just sent over email that can be downloaded by anyone? So these are some of the considerations that we consider as well. And of course, as shared by a number of the panelists earlier also, that this is very much an uncharted territory where e-commerce or tech players are going into areas where the law has not caught up. And we are doing a lot of things where it is still gray. We are following best practices of principles of more traditional laws. So it gets a bit tricky as to whether or not some of these protections will be afforded to us when we use new technology.
Interesting. So, Bignish-san, do you have any comment on that?
I also don't profess to be a tech expert, though I do work with a lot of AI issues. And I think even in Japan, I think I read in the papers just recently the issues with the use of copyrighted material in AI and machine learning. That is a current issue in Japan. We have that issue in Singapore as well. And I'll be very frank and confess that I think before my government and most governments regulate e-commerce platforms, I think we'll most likely try and regulate the use of AI first. That's the reality here. And I think ultimately, when it comes to brand owners, the IP right owners, their interests are primarily self-centered. And I think that's something that we all have to bear in mind. The IP right is an entrepreneurial right that we grant to the IP owner for creating the brand. And it's something that we recognize should be protected. It's a very difficult thing to have a conversation with an IP right owner and a platform and to have them see eye to eye. And I know this because even working in the public sector and dealing with the IP right owners, it's very hard to find a consensus. consensus building is what will make the issues go away. And I think in different countries, as we've heard from all the panelists, we have heard differing ideas about how heavy-handed the government will be in regulating and how light-handed they may be. It really does depend on what the government of the day decides they need to do. In Singapore, the incentive for our government to step in was to prevent scams. It was really to protect the general public. And I think with the issue of pharmaceutical products and services and public safety, that I think everyone can agree on, even the IP right owners. And my purpose here today is to stress that as long as the economic interests of the public sector and the private sector are in alignment, as Serena has mentioned, that you don't want to be known as a platform also that deals in counterfeit products, so they're always happy to work with the IP right owner. Right? As long as all the interests are aligned, then I think we can get some regulation in place, a common set of standards. The difficulty is waiting for that day to happen. And where the motivation is going to come from. In my view, I think it's going to be rather self-help from the point of view of the e-commerce platforms. And once the public sector, the government gets involved to bless the steps taken by the platformers, then I think the IP right owners will have to accept that is the way to go. And I hope that IP right owners can get themselves involved more with the platforms and to achieve an understanding over what the platforms should do and what they don't necessarily have to do, and then to work with the government on these standards, because at the end of the day, the one that the entity, the group of people that would push the public sector into doing something would generally be the IP right owners. So they have to very much be part of this conversation as well.
Thank you very much. Nabarato-san, thank you for waiting so too long. And so, yeah, do you have any comment throughout question 2?
Thank you for the question, and I think I agree with both of Serena and Vignesh that I just would like to have the comments that the important for the nowadays technology is important to develop everything, including the AI, but especially in the field that is hard to identify, such as the patent or pharmaceutical area. So that's why we need to use technology to help us. And one thing that I would like to advise to the IPR owners is keep in mind that before you sell, you have to protect whatever you sell first. Yeah, thank you.
Thank you very much.
Over there, son, can I add something?
Yes, please.
So I think there are two major issues for online infringement. The first issue is for some platforms, the listing from one particular merchant is many. So you can do this takedown. Yes, the takedown procedure works, but most IP owners' ultimate goal is to have that merchant banned for good. That means to have it removed from being able to post new listing. So we have been working with clients to try to have this merchant banned. But the response from the merchant, the platform has not been too consistent. We managed to ban one or two merchants, but we still don't know the criteria that is being implemented by the platforms to have these merchants banned for good, because that is what most IP owner wants. I mean, having worked for most merchants, most IP owners, they want to ban these guys so that they cannot post future listing. So that's one of the issues that's one of the hot topic for IP owners. The second hot topic is merchant identification. Most of the response we get from the platform is that it's protected by data protection. So we are trying to argue that if the party is operating as a trader, then that should not be personal data. And in Indonesia, there's some movement towards registering this merchant, merchant as proper businesses. Still, that's still developing. So the brand owners are also pushing for merchant identification. So I think to summarize that the two hot topics for brand owners for online infringement is how do you ban merchants for good to prevent them from future postings? And the second issue is how do you get the identity of these infringers so that you can take further action against them? These are the two hot topics, actually, from my perspective. Thank you.
Thank you very much. Kim-san is making a closing remarks over working session 1. So the time is coming, so we are close working session 1 and ask audience to make a question.
So we have some time, and we'd like to have a Q&A session now. In the audience, if you have any comments, please raise your hand. Online participants. So here, if you have questions, please give your questions to the Q&A chat function of Zoom. So starting from the audience in this place, if you have any comments or questions, please. And then the person in the middle. Thank you. So thank you very much for your very good presentations and discussions. And also, the panel discussion was so interesting, for which I am appreciative. So I am very happy to be the part of this wonderful discussion. So I have just one question now. So first, we have many panelists participating in this session. So I have a comment or question. So public and private collaboration is important, and IT right owner will make a claim or proposal, and that will be the starting point for the public and private collaborations. So when they make a claim, in terms of the feedback from the IPR owner, do you have any opportunity or the mechanism to hear the feedback from the IPR owner after IPR owner made a claim for the infringement of their rights over the internet? Do you have that system to listen to the feedback from the IPR owner? So, would you like to mention someone? So, Narabat-san, would you like to answer to that question?
Thank you for the question. But I think in my slides, I'm not sure that which slide that mentioned that the signatory of the second MOU on the advertising is have the venue or the function that we will meet in every 6 months to review the implementation of the MOU, and the signatory of the MOU is including IPR owners. So that's why it's a channel that they can discuss or have any comments for the implementation. Thank you.
Thank you very much. Serena-san, do you have anything to be added?
Thank you for your question. So I've observed, so I've been with Carousel for about 7 years now. We have observed the change in how IPR owners have been acting in relation to some of the any infringement in relation to their rights. Traditionally, and I would have to thank eBay maybe for this, it was more adversarial, it was more litigious, where they will send a lawyer to send us a letter to do the takedowns and the likes. But over the past few years, it's been more collaborative. So to your question about whether the IPR owners have a form of avenue to understand more of what happens after the claim, we have seen that there's more of a conversation now that happens with it. IPR owners will reach out to say, oh, my brand protection agency sent this takedown notice. It took X amount of days. Why? Is there something that we can do to make it more efficient? So there are a lot of these conversations that are actually happening.
Thank you. So this is the end of the working session number 1, which is about the measures against counterfeit products by EC sites and other platformers. So the panelists, those participating from the online, please receive our warm appreciation. Thank you very much.